Good morning, this is your Kelso Report for Tuesday, December 13th, and I'm your host, Clark Kelso. Well, the big news of the day is, of course, that the United States Supreme Court has granted review in Arizona versus United States, which involves the constitutionality of certain provisions in Arizona's Support Our Law Enforcement and Safe Neighborhoods Act, which was enacted to address Arizona's illegal immigration crisis. Now, as a general matter, the Act authorizes and directs state law enforcement officers to cooperate and communicate with federal officials regarding the enforcement of federal immigration law, and imposes penalties under state law for non-compliance with federal immigration requirements. The broad legal question is whether federal immigration laws preempt Arizona statutes. The District Court and Ninth Circuit both held the Arizona Act was preempted. Four provisions of the Arizona Act are at issue. First, the Act creates a state law crime of being unlawfully present in the United States and failing to register with the federal government. Second, the Act creates a state law crime of seeking work or working while not authorized. Third, the Act requires state and local officers to verify the citizenship or alien status of people arrested, stopped, or detained without regard to federal enforcement priorities. And fourth, the Act authorizes warrantless arrests of aliens believed to be removable. In some sense, the question here is whether a state can enact laws that, while consistent with federal immigration statutes, clearly put a higher priority on enforcement than the executive branch of the federal government has chosen. In short, who gets to decide how strongly the federal immigration laws should be enforced? No doubt the federal government as a general matter has plenary authority over immigration policy, but when that policy has been enacted in statutes, why shouldn't state and local authorities have the power to contribute to their own enforcement resources? The result of this case is certainly not foreordained, and because Justice Kagan has recused herself from the case, it is possible we will end up with a 4-4 tie, which would mean the Ninth Circuit's judgment would be affirmed by an equally divided Supreme Court without setting a national precedent. My guess, however, is that we won't see a 4-4 tie and that one or two of the conservative justices will join the more liberal members of the court and vote to affirm the Ninth Circuit's judgment. Now on to our one-liners, first in the area of immigration. In Junelang versus Holder, the United States Supreme Court unanimously held that the Board of Immigration Appeals acted arbitrarily and capriciously under the Administrative Procedure Act in adopting a comparable grounds rule to evaluate the merits of deportation cases using standards found in Section 212C, standards that apply in exclusion cases. According to the court, the BIA's rule has the effect of, quote, hinging a deportable alien's eligibility for discretionary relief on the chance correspondence between statutory categories that were developed along slightly different lines for determining discretionary relief for excludable aliens. Unable to discern a reason for the rule adopted by the BIA, the court concluded that, quote, the BIA's comparable grounds rule is unmoored from the purposes and concerns of the immigration laws. It allows an irrelevant comparison between statutory provisions to govern a matter of the utmost importance, whether lawful resident aliens with long-standing ties to this country may stay here, close quote. Next, the Supreme Court had a habeas case. In Hardy versus Cross, the Supreme Court unanimously held in a per curiam opinion that the Seventh Circuit erroneously failed to give the state court's decision in a state habeas matter appropriate deference. According to the court, the Anti-Terrorism and Effective Death Penalty Act, quote, imposes a highly deferential standard for evaluating state court rulings and demands that state court decisions be given the benefit of the doubt. Close quote. Well, the substantive question here was whether the state had exercised good faith in trying to search for a witness to appear at a second criminal trial. It was clear that the witness, the victim of a sexual assault, was in hiding and trying to avoid testifying again. The state trial court decided she was unavailable for the second trial and admitted her testimony from the first trial. Essentially, the Seventh Circuit identified 2 or 3 additional steps the state might have taken to locate the witness. The Supreme Court reversed. noting that the Sixth Amendment does not require the prosecution to exhaust every avenue of inquiry, no matter how unpromising, and the habeas standards do not permit a federal court to overturn a state court's decision on the question of unavailability merely because the federal court identifies additional steps that might have been taken. Well, we also next have a habeas decision from the Ninth Circuit that may get review in the Supreme Court. In Marilillo v. Yates, the Ninth Circuit unanimously held that a California court's Sixth Amendment violation was not harmless, and the court granted the petitioner's request for a writ of habeas corpus. The key causation question at the defendant's trial for first-degree murder was whether the defendant contributed to the victim's death from a ruptured dissecting aortic aneurysm. The autopsy pathology testified at the preliminary hearing that the defendant's conduct did contribute to that injury and death, but he was generally a very weak witness. He did not testify at the trial, but when the defense introduced testimony disputing causation from a medical expert, the prosecution used a written transcript of the pathologist's testimony to impeach the defense experts. The defendant was convicted and challenged the introduction of the pathologist's testimony on appeal. The Court of Appeal, State Court of Appeal, held the introduction of the testimony was indeed erroneous, but held that the error was harmless beyond a reasonable doubt. On federal habeas, the District Court and Ninth Circuit agreed that the state trial court had violated the Sixth Amendment. On the question of harmless error, the Ninth Circuit held that it did not need to apply the extremely deferential standard of review under the Anti-Terrorism and Effective Death Penalty Act, because the Supreme Court's holding in a case called Fry v. Plyler in 2007 held that the Brecht standard of review applied to the harmless error determination. According to Brecht, habeas relief is warranted only if the error had a substantial and injurious effect or influence in determining the jury's verdict. The Ninth Circuit concluded that the Brecht standard was met because the strongest evidence of causation in the case came from the pathologist's testimony, which had been improperly admitted into evidence. I suspect the government will try to take this case to the Supreme Court with the argument that the Ninth Circuit has again erred in failing to accord appropriate deference to the trial court's determination that the error was harmless. The case relied on by the Ninth Circuit, Fry v. Plyler, dealt with a situation where the state court did not make any determination of harmlessness, while the California court in yesterday's case made an express finding of harmlessness, and that decision arguably was entitled to greater deference. Now we turn to juvenile law. In People v. C.H., the California Supreme Court unanimously held that a juvenile court lacks authority to commit a ward to the CDCR's Division of Juvenile Facilities under Section 731 of the Penal Code if that ward has never been adjudged to have committed an offense described in Section 707B, even if his or her most recent offense, alleged in a petition and admitted or found true by the juvenile court, is a sex offense, referenced in Section 733. Now, the relationship between these statutes is complex. Essentially, the Court of Appeals read an exception to an exclusion for sex offenses as though it was an authorization. And the Supreme Court held this was error. The plain language of Section 731 requires that a ward have been convicted of a Section 707 offense. And conviction of a sex offense referenced by Section 733 is not an exception to that Section 707 requirement. Next, in Re M.B., the 4th District upheld the inherent authority of the juvenile court to issue an injunction against the mother of a child in foster care from contacting employees of the County Department of Children and Family Services except through her counsel. The injunction was triggered by the mother's series of threatening and harassing phone calls to the department, including a statement to a therapist that the mother had threatened to shoot the social worker. Now we turn to health law in People v. Guzman, where the 2nd District affirmed a physician's conviction on one count of submitting a fraudulent Medi-Cal claim when the claim filed by the physician represented that he was supplying a patient with an expensive FDA-approved intrauterine device when in fact he was supplying his patient with a cheaper, non-FDA approved intrauterine device. The doctor claimed there was insufficient evidence of the required intent to defraud because the incorrect information on the claim form was generated by a computer program automatically. It simply hadn't been updated to reflect the office's most recent practices. As the appellate court noted, that's a good argument at the trial level, but here it ignores the factual finding by the jury. On appeal, the physician's case was really fatally undermined by two facts. First, the invoice on which he was convicted was submitted 5 days after the office had been visited by the investigators who told the doctor about the allegedly false invoices. He should have fixed it. Second, and most damning, when the investigators asked him to provide all invoices for the cheaper device, his office provided forged invoices, which of course gave rise to a reasonable inference of consciousness of guilt. He should have checked those invoices before his office sent them along. Next, in the area of class actions, in Pirjada v. Pacific National Security, the Second District affirmed the Superior Court's decision to give the plaintiff's counsel 60 days to try to find a substitute class representative when the sole representative settled his claim directly with the defendant's CEO. The court also affirmed the Superior Court's rejection of the plaintiff's counsel's motion for pre-certification discovery to help identify a suitable class representative, concluding that counsel was free to communicate with anyone who might wish to pursue a claim, but they weren't entitled to discovery to help them do that. Next, in the area of appellate jurisdiction, in Starpoint Properties v. Namvar, the Second District dismissed the appeal for lack of jurisdiction when the appellant failed to file its notice of appeal within 60 days after service of the notice of entry of judgment. The appellant had filed a motion to vacate the judgment within the 60-day period, which normally would have extended the 60-day period by 30 days. But the appellant then withdrew that motion and then filed a new motion to vacate 4 days after the 60-day period had run, apparently believing that the first motion to vacate was enough to trigger the 30 extra days. To the appellant's surprise, the Second District held that the withdrawal of the first motion to vacate and filing of a new motion with new and different arguments did not preserve the 30 extra days. Accordingly, the second motion to vacate came 4 days too late, and the court was required to dismiss the appeal for lack of jurisdiction. Appellant's counsel is going to have a really tough explanation to make to his client, although the appellate court helped things out a little bit by at the end of the opinion indicating that, well, even if there had been jurisdiction, he was going to lose the appeal anyway. That's the appellate court being very nice to appellate counsel. We have two additional grants of review by the Supreme Court of the United States. First, a bankruptcy case. In Radlack's Gateway Hotel versus Amalgamated Bank, the Supreme Court granted review to resolve an important, though technical, issue under the bankruptcy laws: whether a Chapter 11 plan can authorize the sale at auction of a secured creditor's collateral, free and clear of the creditor's liens, without permitting the creditor to credit bid, because the plan ostensibly provides the secured lender with the indubitable equivalent of its claim. Excuse me, the question pits two statutory provisions in the Bankruptcy Code against each other, and the court will decide which section is left standing. Finally, in the area of sovereign immunity, in Match E.B. Nash She Wish Band versus Patchak, the United States Supreme Court granted review to decide whether a challenge to the Secretary of the Interior's decision to take certain Indian land into trust for use by a tribe as a casino is reviewable under the Administrative Procedure Act, or instead is not reviewable because of the Quiet Title Act, which restricts actions against the United States under that act with respect to Indian trust lands. The court may also decide whether a member of a nearby community which would be affected by building a casino falls within the zone of interests and therefore has standing under the Administrative Procedure Act to challenge the Secretary's decision. Well, that's it for a very busy day in the Kelso Report. Have a great day in the law.